Are we ready to go?
Yes.
Okay. Good morning. This is Patrice Campbell, the chair of the board of the real estate appraisers. Today is January 6, 2022. It is 9:01 a.m. This is a public meeting of the board of real estate appraisers, and we will now call the meeting to order. If we could have Marcia Waters perform a roll call.
Chris Brownlee.
Here.
Mickey Sanders.
Here.
Chris Chippendale. Patrice Campbell.
Here.
Christy McFarland.
Here.
Larry Stark.
Present.
And Tony Pastilli. Will you have a quorum?
Okay, the next matter is to approve the board meeting minutes from November 4th, 2021. Can I get a motion to approve those minutes?
Larry, make a motion to approve.
Second.
And a second, please. Thank you. All those in favor say aye.
Aye.
Aye. Aye. All opposed? All right, the next item, are there any other matters that we would like to discuss? Nothing? All right, next, we can move into policy. This portion of the meeting is, this is a citizen participation period. Any person may bring their concerns about matters not on the agenda before the board. Speakers are requested to limit their remarks to 2 minutes unless allowed additional time by the board. Are there any public members that would like to speak?
So if anybody from the public would like to address the board, if you look at your control panel, you'll see an icon that looks like a hand. If you click that, I will call your name and unmute you. Madam Chair, it does not look like there's anybody wanting to speak to the board.
Okay. The other policy matter we have is appraisal professionalism. And I believe, Tony, you brought this to the board. Did you want to discuss that?
Madam Chair, thank you. Board members, I think we spoke about this a little bit at the last meeting, and this was just a follow-up communication. In the meeting materials, there's an email exchange with an appraiser and some correspondence with the Appraisal Foundation. According to our counsel, there isn't much that we can do in addition to enforcing provisions of USPAP, which really don't apply to professionalism. But I think this is an emerging issue, and one that if there is a unique or creative way for our board to address it, I know other boards have, but they may not be limited by the same legislation that we have. I think we as a profession should be acting differently than this appraiser did in that email exchange. And I know that's just one example, but there are many others as well. So just for information, unless, Chris, if there's something that you can provide as background.
Madam Chair, may I add something to that?
You just want to go ahead and add it, Chris?
Yeah, that's fine. this is Mr. Pastili, board member Pastili has identified an issue, and that the board certainly is able to address as much as it can to the extent that in addressing that issue, an action constituted an additional requirement beyond that is more stringent than a requirement in the federal law. That's really the bar that we could potentially talk about, but that's really the bar that board member Pastili was referring to. This board is not able to, or its requirements cannot be more stringent than those in applicable federal law. So to the extent you're addressing professionalism issues, you need to look to comparable applicable laws.
So, Chris, did I understand correctly? I mean, there's nothing we can do for lack of professionalism. I mean, there is. Can you hear me, Chris? Yeah.
Yes.
Is there anything we can do for I mean, this was an extreme lack of professionalism for certain, and I'm sure there are others out there, but if that were to occur in Colorado, is there anything that we as a board can do, or is it, as this memorandum said, that, the AMF, AMS, whatever, can remove them, but then they go on to work for somebody else? I mean, is there anything we can do?
Well, certainly to the extent that the lack of professionalism manifests itself in the form of a standard violation, whether it's the ethics rule or something else, that certainly falls within your authority and jurisdiction. Or if it veers into the area of fraud, for example, but then you are, that is certainly within your authority. The concern is, without a separate federal level rules regarding professionalism, we'd be looking at the potential issue of more stringent than currently exists at the federal level.
Right. Anybody have any other comments?
I'm having a little trouble with my, I'm having a little trouble with my connection, I think, so I'm going in and out. No other comments at this time. It's just something I guess we can be aware of at this point, and
So, I have one other question. Chris, do we have any examples of this that have come to the forefront for the Colorado board where there's been extreme lack of professionalism? I mean, if the person's report is done well and they act unprofessionally, it doesn't seem like that there's really anything we can do as a board. So is that a fair summary? The report's well done and they are disrespectful to their client. That's something the client deals with currently?
And that is the current situation. I mean, it's to the extent this board is, its powers are set forth in the organic statute, and it's really tied to largely use violations, but other dishonesty. I mean, again, if it veers into the area of fraud, that is a separate violation. But and I perhaps would have those with the division staff speak to this as well. But if it's an area outside of those types of standards violations, generally speaking, it's outside the authority of the board to discipline it.
Okay, thank you.
yeah, thanks. Well, thanks for bringing it. I think it is possibly a growing issue out there in our world, so we can deal with it as best we can going forward.
One last question, Madam Chair, if I can. Chris, do you believe within the ethics standard or rule within USPAP that there's a way to address these kind of issues?
as you know, part of the USPAP, the ethics rule, involves performing an assignment in a grossly negligent manner. If the conduct were to arguably fall into that area, I mean, that's one example I can think of, and I'm certainly open to further discussions, whether here or in executive session going forward. That's just one example that
I apologize. I didn't mean to put you on the spot, but, and if the conversation isn't appropriate at a public meeting, I would be, for one, would be interested in pursuing it later at a more appropriate time and venue as well. And I could supply, for this one example, I could provide 10 others.
Yeah, I think it would be great for us to arrange a session that's available, that's convenient to everybody, because I think it is an issue and it's something that we would be remiss if we didn't discuss as a board.
Thank you. Thank you, Madam Chair. Board members.
So do you want something added
Thank
to
you.
the later agenda? Because it's going to have to occur in a public meeting. It's just going to depend if you're getting legal advice about something specific, then it would be an executive session. But we wouldn't actually schedule a special meeting for you to discuss appraiser professionalism.
Yeah, I don't anticipate it being a lengthy conversation, but just a conversation. I'd like to have the conversation to see if there are any other options available within use.
Do you want me to put that on March's agenda?
If that would be the appropriate process, yes. Thank you.
I do have a question for you, Tony. The example that you provided was from California. Do you
Yeah.
know what other states are doing, or do the appraisal management companies have any kind of procedure in place across the nation to track individuals like this?
The appraisal management companies don't have a system in place to track. I don't think we would want that as an appraiser community. However, it did come up at the Aero meeting last fall, and there was broad support from regulators, AMCs, and individual appraisers and lenders in the room. And it was a lengthy conversation, and there was consensus. And this is just, an example of one of them, maybe one of the more egregious examples. But there's a lot of these in different forms and fashion about not being professional. It doesn't rise always to this level. But the issue that was identified by the AMCs is they can take action and take them off their panel. But then, they still live to work for another AMC and continue to do it unless there's something at a higher level that addresses professionalism. This never really, it's kind of like grabbing a balloon. They're gonna go somewhere else and continue to behave the same way.
It seems it's like an employee that gets fired from one company, and because of HR rules, all that a former employer can say is that employee is no longer is not available to be rehired, but you can't get into any more specifics. So it almost seems like the AMC companies need to come up with some kind of a standard that, I don't know, it's a national issue.
Yeah, and Christy, that's why I first reached out in April of last year to the Appraisal Foundation and asked if this was something that they thought would be appropriate to address within USPAP. And y'all see the response.
Right.
It's not something they want to do.
Yeah.
As a profession, I think we'd be remiss if we didn't have professional standards. I would guess that other professions, including attorneys, would perhaps face discipline if they responded to clients and consumers and public like this.
I agree. It's a sticky wicket.
Mm-hmm.
Just to kind of go along with what Tony's talking about. I agree, Tony, that this is an issue. And speaking from someone on the AMC side, and I apologize for my camera. I'm not sure what's happening there. I hope it's not affecting the audio. But I have a couple of examples that of similar type things. We usually get it more instead of being written. It's usually where somebody turns verbally with our coordinators and, kind of goes on the rant against our coordinators. And we do have things internally that we do. That's not the type of appraiser, not the attitude we want to deal with on a daily basis. And we make notes in our own system for that. They don't typically continue to do work for us after those, an incident like that, or if we receive something like that. And we have received a couple of those in writing that very similar to what Tony gave us as an example.
And this one, board members, this one refers or relates a lot more to inappropriate language, vulgar language. But the issue of ghosting that Mike Simmons from Axis Appraisal Management Company brings up is very real. I'm responding to one just today. The assignment was complex. The appraiser said, yeah, I'm not going to do it. And after repeated calls to the appraiser to get him to complete the assignment, he just, quit responding. I don't know that that's, what we ought to allow or permit to exist and there probably are areas of USPAP to cover that, but as a board, I think we may need some guidance on how best to address this. If we all agree it's not a desirable behavior, how do we, in Colorado, do a better job of educating appraisers so that they don't do this? And then how do we react if they do? Maybe that would be a good takeaway for staff to consider for a future meeting.
So then, Marcia, you're going to put that on the March for an executive session, or?
Yes, I will.
Okay. Okay, any other comments? Thanks, Tony. Any other thoughts on that? Or? Good. All right. Now first we have complaint 2021-1299. Robert Walker was the investigator.
So, board members, with complaint matter A, the complainant alleged that the respondent had racial bias as well as bias against engineers. In reviewing the report and the work file, there were several potential use violations identified. There appeared to be scope of work and record-keeping rule issues. The respondent failed to document, analyze, and support the reasoning used to select the comparable sales and the adjustments made or lack thereof. In the sales comparison approach, neither the site value methodology nor the replacement costs were supported in the cost approach. There was no true consideration for developing the income approach, despite a significant number of rental houses on the same block as the subject. And finally, there was insufficient summaries of analysis to support the opinions and conclusions made in the report. This results in potential violations of 12-10-613-1B and G, Board Rule 12.12, the Record Keeping Rule, the Scope of Work Rule, and Standards Rules 1 and 2. The recommendation is for a stipulation for diversion and coursework, 5 hours of data verification, and 7 or more hours of comparative analysis and or supporting adjustments. And Rob is here to answer any questions that you may have.
Hey, Rob, this is Larry. So going through this, from a sales comparison approach, though there wasn't great or there wasn't necessarily support for the adjustments, the comps seemed reasonable to me. I didn't look, of course, beyond the data that was provided. Were you suggesting that there were better comparable sales? I mean, there were a tight range. The appraiser concluded within the range. The appraiser made time adjustments to the one sale that was a few months before. So I didn't, unless, and excluding support for the adjustments that were made, the sales seemed reasonable. Am I wrong in that?
No, I think actually this one that the sales were very reasonable. What I was trying to get to in that, what I'm trying to explain to a lot of our respondents is we're just looking for a little bit more documentation of the reasoning, the selection process more than the particular sales. This one it was, I mean, they were all probably within a half mile or a mile. So the selection was good. We just wanted asking for a little bit more documentation and kind of more of the thought process of what's going in through the selection process, the filtering down from, the larger amount of potential comparable properties. Why are you selecting these particular ones? And when I'm doing that, I'm not making any sort of judgment. I'm just trying to get an idea of the reasoning.
Yeah, I was just curious if you thought that was good. And then my follow-up question to that would be, and having used MLS, a lot over the years, I know that you enter parameters and you got different averages and ranges than the appraiser did. And this is really more a statement than a question. I just know that we can have 5 people in, we're not residential, but we can have 5 people in our own office enter the various boundaries. Unless things are entered exactly the same, you get different results. So I hesitate to criticize the appraiser because they had slightly different range of high and low and averages. And I noticed that in a lot of the reviews, and it may be that they use slightly different boundaries. I also know MLS data changes from month to month, so you may be 3 months behind them. And even though maybe there's a way for you to go back and enter those the criteria, you may get different results. So that seems to be a reoccurring criticism, and I think that's a difficult one for the appraiser to defend. And then another question that I have related to this is we talked about perhaps the need to do a gross income multiplier or some kind of income approach associated with it, which is certainly not atypical if there are a lot of rental properties. And frankly, you'd want to see, does the rental value represent a higher value than the sales comparison approach? We don't know if the buyer was buying it to rent, if the buyer was buying it to occupy, I guess. But how did you discover that there were a whole lot of rental properties that weren't addressed? Did you do a search through some?
I believe it was a search on the Colorado Springs MLS. They have a lease thing, and I just basically I put in just the subdivision name. A bunch of things came up, and then I noticed, oh my God, there's like 6 of them on the same street. Yeah. So I wasn't actually, I'm not looking to prove somebody wrong. I'm just seeing what available information is out there, and I'm just trying to state that there is quite a bit of information. Maybe that should have nudged the appraiser to look into it a little bit further.
Sure. I mean, Rob, if there were 6 on the street, they should have used the income approach. And then final question, and this is for all of you guys who are so heavily involved in residential real estate appraisal. At what point do you believe the cost approach becomes less meaningful? I mean, trying to estimate depreciation on an asset that's 11 years old that has had work done is at the best, an imperfect science. So at what point, Tony, or some of you guys who deal with this daily, at what point do you say, the cost approach probably isn't that meaningful?
I'll take a stab at that. I guess maybe from another direction, it's very meaningful in new construction, but as the property ages, it probably gets less and less meaningful. I don't know that there's a hard and fast line of how many years, before it becomes less meaningful or not necessary. That's an appraiser decision on that specific property.
Sure. I mean, I understand that. I guess my question is, so this asset's 11 years old. I would have attempted to do a cost approach. I just was, kind of curious as to the general consensus. I mean, when a property's 50 years old, it's probably fruitless, right, to do a cost approach. I mean, how do you estimate the depreciation? So, because I notice in a number of the residential reviews that we're doing as well, there's this conversation about the cost approach, and I just didn't know if there was a particular. And I understand there's not a demarcation at which we would say, well, it's not useful at this point. It's the appraiser's judgment for certain, but just curious if you guys had any standards that you followed. So those are all my questions.
So Larry, you may know that, oh, excuse me. Go ahead, Patrice. So Larry, you may know that the assessor's office around the state, we only use market approach to value residential properties. And in our small county, we rarely use the cost approach for commercial and other properties.
Right. I appreciate that.
I would just point out, just as a side note, that I see in this investigative report how the respondent said that she wanted to check the MLS to verify the sale amount. And from my experience, the MLS, all of the attributes about a property are actually derived from the assessor database. That's how the MLS is populated, and then the sale and the sale date is hand entered into the MLS. And there are numerous errors that I see. The assessor's office is really the better like to verify sale amount and the sale date.
Or even the deed. Look at the deed.
True, exactly.
And the other thing with the cost approach too is, I think it doesn't. I haven't been in the residential world for a few years, but it depends on the assignment and the purpose. So it can vary on that. You should be supporting your land value to get your comp. It's very minimal. But I agree with Larry on a lot of this. I thought some of the things brought up were pretty minor. There was not good support of the adjustments, but some of the things, and I'm not sure, I mean, if the respondent would have explained better why they didn't use the income approach, I think that would have even been fine, like not an income producing property, but again, it's a little lack of, as Rob said, a little lack of just communication on what was used and why it was used. But I thought the costs were fine. I thought, and I agree with Larry, you can look on one day and pull your parameters, and the next day you can pull it from MLS and get something completely different. So I didn't have too, and I think within that range of value, had this person gone a little bit different, nobody would have ever made any comments on this appraisal.
I totally agree. I haven't really addressed the issue, and maybe we don't address the issue, but I didn't find anything in the report, and I guess it's really kind of beyond our ability to determine was there racial bias. I did appreciate the respondents' response to this, and that they have a racially integrated family, et cetera, et cetera. That certainly doesn't mean that there wasn't racial bias, but it would suggest to me that the person probably isn't looking racially when they're doing a report. And just because there was a differential of $10,000 on $375,000 or whatever the value was, that doesn't suggest to me that there's racial bias. But I guess it's hard to get inside the head of the person that was doing the report or the person who the report was done for.
I agree, Larry.
So
the discipline.
I'm sorry, I was just going to say, summary for me, I didn't find the report terrible by any means, to use the word terrible isn't appropriate here. I thought they could have offered better support for the adjustments that were made. Given what Rob has said, there probably should have been an income approach, because sometimes the income approach suggests that the property may be worth more or less, as a rental property. If there was 6 on the street renting, that's a lot of rentals in the market. So that's something that should have been done, and I'm not so certain about the cost approach. I think that they should have had, there probably aren't any lot sales nearby, but they could have gone to perhaps another neighborhood that has lots that are being sold to builders. But my guess is the average home price in that neighborhood is going to be a lot higher. And I would say it's probably beyond the scope of a residential appraisal to try to go through and do some kind of extraction methodology to get a lot value. So, I mean, I'm empathetic to the appraiser. It's hard to estimate a lot value in a single family subdivision that sold out 10 or 11 years ago. So those are my thoughts.
So this appraiser
So the
has been
recommendation-
previous, a 2012 dismissal with subsequent education and a 2014 stipulation for diversion. Given that previous history, I find that the recommendation by the staff is reasonable, which is 5 hours or more in data verification and 7 hours or more in comparative analysis and supporting adjustment.
I agree. I think that's fair.
So do we want to go ahead and get a motion to recommend the disciplinary recommendations?
I would just add again, you're all the experts, and just listening feels a little heavy in terms of time spent on this, and you all would know best, but just as I'm listening to the conversation and trying to compare it to, again, the short window I've been with you guys, it feels a little heavy to me. I'll just throw that out there.
So we're talking a total of 12 hours, is that right? No fine and 12 hours of coursework.
Correct.
And then, Christy, what did you say that history was again? This wasn't the first issue, right?
That is correct, and that is why I support the staff's recommendation, because there was a dismissal with subsequent education in 2012 and a stipulation for diversion in 2014, which required 15 hours of use PAP and 7 hours of land and site valuation. So this would be the third complaint coming before the board.
So, Chris, I would normally agree with you that maybe a single court targeted whatever the most significant issue was would be appropriate. But because of what Christy just reviewed, the fact that even though they're distant in time, the fact that this is the third situation, I don't really have a strong opinion that 12 hours is too much. So.
We can also consider reducing it to just the 7 hours of comparative analysis or supporting adjustments, because the primary complaint that I hear from all of us is that there wasn't enough support for the adjustments.
That's the one issue that I really, I think that that's the course that for certain should be taken. So.
Okay.
So do we hear a motion that we reduce the suggestion to just the course for, I think it's a 5-hour course for adjustments?
7 hour.
7 hour?
7.
All right, thank you, Chris. I concur.
So on complaint 2021-1299, we have a motion to reduce the disciplinary recommendation to 7 hours or more in comparative analysis and or supporting adjustments. Do we have a second on that?
Second.
All those in favor say aye.
Aye.
Aye. All those opposed? Okay, the next complaint is 2021-1515. Robert Walker was the investigator.
So, board members, complaint matter B is a complaint where the complainant alleges the respondent used inappropriate comparable sales due to dissimilarities in location, site, and age. In reviewing the report in the work file, several potential use pact violations were identified. There appeared to be scope of work and record-keeping rules issues, as well as a potential ethics rule violation for manufacturing a work file after the complaint was filed. The respondent also failed to fully analyze the subject property, the neighborhood and market area, potential zoning issues, or to document the analysis used to select the comparable sales and the sales comparison approach. There was little to no support for the adjustments made in the sales comparison approach. Neither the site value nor the replacement costs were supported in the cost approach. There was no true consideration for developing the income approach, despite the house on the subject property being actively leased. A comparable rent schedule was included in the report, and a commercial business was being operated out of the unpermitted building on the property. Finally, there are insufficient summaries of analysis to support the opinions and conclusions made in the report. The investigation identified potential violations of 12-10-613 1B and G, Board Rule 12.12, the Ethics Rule, the Record-Keeping Rule, the Scope of Work Rule, and Standards Rules 1 and 2. The recommendation is for a final agency order, work product review of 4 appraisals in 2 months, and coursework consisting of the 15-hour use path course, residential sales comparison and income approaches, that's 30 hours, and the BOREA work file course. And Rob is here to answer any questions that you may have.
So Rob, this is Larry. I don't mean to be the person that keeps standing up here, but so is it a legal non-conforming use that they're operating this thing as a commercial property, or is it in within the zoning code that they can operate a commercial business in this on the property?
I don't believe there was. It is owned for a commercial business. Also, the way I discovered this is I just happened to be going through the assessor's record, and the assessor had no record for this building whatsoever. So it looks as if, and then actually I contacted the assessor's office, and the building hadn't been permitted at all, even though it's a fairly large structure.
I mean, as I look at it, I can't tell exactly, but and I don't know if this matters, but it looks like the house is being used as residential, and then they've got a business in a back building. It's hard to tell which building was which. Is that what it looked like to you?
Yes, actually, I think the house was being rented, and I believe the owner of the property was operating his personal commercial business out of the back. There were 2 outbuildings, and this is the larger of the 2. I believe it actually had a second story with offices, and it's a substantial structure.
Well, no doubt this would have been a hard residential appraisal to do because it's some hybrid. But
it was the building that was non-conforming, correct? Not just the business. Your issue was that the building wouldn't have been allowed to be reconstructed.
It would not. The building would not be allowed to be built because it was not. Initially it was not permanent, and then I believe due to the size, I think there were some size requirements of the actual lot had to do with what sort of the size of the building they would allow, the city would allow or county would allow to build.
But from a residential standpoint, if you were reviewing this, I know when I did residential work, I would have just not put any value on this building and discussed it that it was there but non-conforming. I don't know what the current protocol is for something like that. Chris, can you speak to that?
So, is it illegal then, Robert?
To be honest, I have no idea if it's illegal. All I know is it was an unpermitted building. And you're not supposed to have a commercial building or a commercial business run out of a residential neighborhood.
Because that, to me, that's a big part of that, is if it's illegal with the current zoning, then that's something, in our engagement letters anyway, if we have an appraiser that finds something is illegal with the current zoning, they're immediately to contact us. So we can let the lender know if they want to try to go forward with it or not. Usually that would just kill it as residential. You know.
So I guess the fact that it's not really addressed, I mean, there are two issues here. They're running a commercial business in an area that it sounds like they shouldn't be, but that will go away at the sale, you would assume. It sells, and then the new occupant, we can only assume, isn't planning on running a commercial business out of there. So the real question to me is the building, though it wasn't permitted, could they go back to the county or to the city and go through the process and have the building perhaps brought to code if it's not, and have it be, there's going to be a process one way or the other because it wasn't permitted. So I guess we don't know, and the appraiser didn't address, is this legal or illegal? Is it and it's certainly not a legal non-conforming, because we can't assume that because it didn't get a permit. So there are a number of things in this report that I guess should have been addressed that really weren't. So
Yeah, even his statement of highest and best use that Rob pointed out didn't really make sense of what he was trying to say. And then this market, in addition to that, there's some issues with the sales, and maybe were there better sales out there to use?
Well, one of the main issues was he was saying the importance of the outbuildings. That was probably the driving factor of his comp selection. And if, for instance, and the value that those provide, but if this is an unpermitted building, he should have looked into that a lot more. He just assumed it was a unpermitted building because it was a nice building. And then none of his comparable properties were within his neighborhood boundaries as well. So I'm not exactly sure how he chose these, other than that they had large outbuildings.
And they were all, this one that had a lot of, most of the other zoning was agriculture, and this one was residential.
Exactly. This one, I believe, I should double check, but I believe the others were residential, which would give them a lot more leeway as far as the construction of the outbuildings.
you mean they were agricultural, and that would give them leeway for construction?
Exactly.
Well, I mean, from the appraiser's perspective, I can certainly see why, if you thought everything was a legal conforming use, it would have driven you outside your neighborhood to find comps that actually have substantial outbuildings, that because the quality of that outbuilding looks, very nice. So I could see how that would drive you outside the neighborhood. So from my perspective, I don't know these neighborhoods, but I would say that I would have gone outside the neighborhood. Then I would have tried to explain the neighborhood differences. And I would have explained, as I think I remember reading in here, that the reason for pursuit was she was looking for buildings that had outbuildings. I mean, that was pretty clear. Nonetheless,
Didn't discuss the difference in zoning, which is probably one of the key things to have. Yeah, there was some issues with not understanding the subject property and not communicating it with the client.
as Chris said, if I were the lender, I certainly would have wanted to have better information than was provided by the appraiser. So this might have been one of the appraisals that you do the inspection and you call and you stop the process. So Christy or somebody, could you tell me again what the recommendation for coursework or Marcy? I got the 30 hours. I got 4 reviews of 4 appraisals. What else was there?
So it's a final agency order, 15 hours of use PAP, the 30 hours of the residential sales comparison and income approaches, and then the BOREA work file course, in addition to the work product review of 4 appraisals in 2 months.
The 4 appraisal work product review come from what you believed your conversations were with the appraiser, Rob?
So Rob actually didn't make the recommendation. What I did,
I don't make that.
yeah, I'm the one that makes the recommendation for you guys. What I did was I looked at the fact that he's got prior board actions. And really I would anticipate that a certified residential appraiser would know to do the research necessary to complete this assignment.
Right, okay.
But you're more than welcome to deviate from what we recommend, obviously.
So let me ask this of the people that are in the single family world. How difficult is it going to be to get somebody to review 4 of your jobs in 4 months, given, I don't want to prevent this person. I don't want to set them up for failure. If they can't get 4 reviews done in 4 months, and maybe they can, but is that going to be difficult, Chris or Tony or somebody that really does residential?
You know, the board members, there's a program in Texas that addresses these kind of issues, and USPEP instructors are paid $75 for a review of a property, and it happens all the time. There's a panel of instructors that are willing to do that review. It's relatively cheap. It's paid for by the appraiser, and you know, if it's successful, they move on.
We don't have that though, right? That's Texas. Is that
Correct, but no reason why we couldn't. It seems it's a model that's out there, maybe a best practice that we could emulate.
right?
In the interim, if you pay enough, I would be in favor of charging the appraiser for the reviews and asking the state to facilitate ordering the reviews.
So
I think in the past,
they usually,
yeah.
they usually will find somebody to do the reviews, and it usually does cost them money to have that other appraiser do the reviews. And we just need to make sure that the reviewer is in good standing and adequately credentialed to do it. So that's our involvement in the selection is very minimal. We just need to make sure that they're qualified and in good standing to do it.
Do we review Madam Chair, Ms. Waters, do we review the review to make sure that they're doing an adequate review? And that's the purpose of the review, right?
Well, correct. No, we don't usually review the review. The reviewer will communicate with us if there's been any deficiencies or any concerns, and we go from there.
So we let the appraiser select the reviewer?
But the board has to approve it. So, and we do that on your behalf by making sure that they're in good standing and adequately credentialed.
Okay. Doesn't sound like a lot of independence there, but I'm okay with that if that's what we've always been doing. I do have, Madam Chair, a couple of questions on this. Do we know for certain that the site is zoned residential?
I believe there's something in the work file, there's probably an addendum or an exhibit that would have that. I can go back and take a look.
Online sources, and I didn't have access to MLS, but online sources indicate that the property is zoned agricultural, and maybe that's incorrect. The other question: do we know that there is no permit on the outbuilding?
We do. That was verified by the Weld County, the Weld County Assessor's Office.
And And then do we know that it's a non-permitted from zoning, that it's not allowed to be there? The fact that he's using it as an air conditioning shop doesn't concern me as much, because I know we as appraisers work out of our homes all the time, and I hope we don't have limitations on commercial activities in our homes, but just so it's conforming to the neighborhood. It looks like just outside of this area, this house might be a little closer in town to Greeley. And I admit, I don't know the area in Greeley all that well, but it looks like there's comparables, and this would be an attractive property. I just want to make sure that we know for certain that what we're alleging is actually correct, that the appraiser missed the zoning, that the property isn't allowed to have a building like that. There's enough other comments and issues with the appraisal for me to go forward with discipline, but I want to make sure we have our review in order before we say it's a problem.
So I agree, Tony, with what I was trying to say earlier, and I didn't look because I don't think that's within the scope of what our responsibility is as the board, but I didn't look at county records to see if this is residential or agricultural. But if it's agricultural, it's much more likely that this building, though constructed maybe without a permit, might be able to after construction go through the permitting process, be modified, and be a legal use. And as long as it's within the appropriate setbacks and it's a legal use, it would change my perspective on exactly how to proceed here if that were the case. So, and I don't know if
you have an email from the county that says it's residential.
Yes. Exhibit A says it is residential from county.
Okay.
I see that. I apologize. I see that now.
I believe it's not that the commercial nature of the business, commercial business being there. It's the actual size of a building relative to the size of the lot was the issue.
On this one of the things Larry was talking about, and Tony there, I listened to a lot of that interview, and when Robert was talking about the building not being permitted, I was kind of surprised that the appraiser seemed surprised. He didn't seem to even be aware that it was not permitted.
Well,
No, he was not aware.
Yeah, one of his comments was that he thought it was beyond the purview of his job as appraiser to look up the permit.
You can see by just looking at the assessor's record, there was no record of that building on there. That's how I found it. I'm not saying that's up to him, but I would think if you adequately review the assessor's records and see that one of the major factors that you're basing your comparable sales on is not on the assessor's records, you may want to delve a little bit deeper.
True.
And Marcy, you said there was a past occurrence of some issues with this appraiser.
There has been. I mean, the most recent was a 2019 complaint, and that involved some issues with a condominium appraisal. And then let me double check I think he's got something else as well. He had a 2016 case that was a dismissal with subsequent education.
Well, I guess my final perspective is there certainly some issues with the report, and I have to agree with Rob. I think that if you're basing all of your comp selection off of the fact that the property is a bit of an anomaly apparently in the exact neighborhood because it has substantial outbuildings, doesn't matter what their use is, just substantial outbuildings, going to assessor's record is pretty easy just to see how many square feet they show that exist, and perhaps that would have let this person know that one of these buildings was in fact not permitted. So, I mean, it could be an honest mistake, but boy, that honest mistake sure could cause a lender a lot of problems if they made a loan on this deal. So, the number of hours, I don't mind the 4 appraisals being reviewed, and the cost wasn't at all the issue for me with the appraisals being reviewed. The issue is these folks are so busy right now, are they going to be able to find somebody to do the review? So I guess my perspective is we're giving them 4 reviews in 4 months. I think that having grace, if they can't make that happen, takes them 5 or 6 months would be something I think is appropriate. And it's a lot of hours that we're suggesting that the person taking coursework. There were so many kind of practical issues in this. I'm not sure what all the coursework should be, but my thought is the hours seem heavy, but maybe they're appropriate. Given the misses here, I probably would have had less hours, but.
Also, Larry, would you rather? It's 4 appraisals in 2 months. So, would you want to see 2 appraisals in 2 months? And
2 and 2, two appraisals in 2 months. Is that what you said?
Well, yeah. Would that be more?
Or 2 appraisals in 4 months, perhaps. I mean, seriously, if timing is a problem and they aren't as busy, and the other suggestion would be one of the coursework requirements is 30 hours of residential sales comparison, and perhaps in lieu of that class, the supporting your adjustments, the 7-hour course might be more appropriate. That would lessen the total hours.
Yeah, I mean, I would be for Teresa. 2 reviews in 4 months. I mean, that is not. That's something that I'm sure that this person can accomplish, and doesn't really create like I said, setting them up for failure. And then, not knowing exactly the extensiveness of the past 2 complaints. I mean, doing that 7-hour course for supporting adjustments. And then I kind of agree with the 15 hours of USPAP. I mean, there's some real USPAP misses here. And I think that taking the 15-hour USPAP isn't bad for any of us at different times. I would say that they should be able to use all these hours that they're taking as hours towards their required number of hours for their annual education.
So, board members, they're not allowed to do that when you do a final agency order or a stipulation for diversion. Okay. And I didn't recommend the 7 hours of supporting your adjustments because he was required to do that for the 2019.
2019, I see that.
So what's another alternative? So he did that. What's an alternative to the 30 hours?
So I could look for a course about appraising complex properties.
I think that's a great
That
idea.
would be
That's a great idea.
And we do work with them. If they have difficulty getting the reviews done within that 2-month window of time, we will work with them on that.
Okay. But does somebody want to make a motion on?
Well, let me ask something first. I believe what Patrice said wasn't a 2-month window, but it was 2 appraisals in 4 months. Is that right, Patrice? Was that?
That's what I said, just to give them plenty of time. But if Marcia wants to work with them and we want to say 2 appraisals in months, I agree. Don't set them up for failure.
Yeah. All right. So I'll make a motion. 2 appraisal reviews in a 4-month period. If we can find a course about appraising complex properties, I think that would be an appropriate course. The 15 hours of USPAP, and none of this will be used for their continuing education.
And the
The other-
BOREA work file
Yeah.
course.
Exactly.
Yeah.
And this is a final agency order as well. I second that.
On complaint 2021-15-15, we have a final agency order with coursework including a 15-hour national use map class, a BOREA work file course, a course to be determined on complex residential properties, and work product review of 2 appraisals in 4 months.
Second.
All those in favor, say, oh, okay, yeah, I thought we seconded. Got a
Aye.
second? All those in favor say aye. 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 All those opposed? Okay, on to the next complaint is complaint 2021-1593. Robert Walker was the investigator.
So board members, I'm going to combine C and D for you. I'll read them each separately, but the disciplinary recommendation is combined because it's the same respondent. So in complaint matter C, the complainant alleged the respondent used inappropriate comparable sales and unsupported adjustments. In reviewing the report in the work file, several potential use path violations were identified. There appeared to be scope of work and record-keeping rules issues. The respondent also failed to fully analyze the subject's amenities and condition, the neighborhood and market area, or properly document the analysis used to select the comparable sales. There was little to no support for the adjustments made in the sales comparison approach. The reasoning for developing the cost approach was because it was not required by the client. There was no research or analysis in the consideration to develop the income approach. Finally, there are insufficient summaries of analysis to support the opinions and conclusions made in the report. So it's complaint matter D, and that's case number 2021-1936. The complainant alleged the respondent used inappropriate comparable sales and unsupported adjustments. In reviewing the report and work file, there were several potential use path violations identified. There appeared to be scope of work and record-keeping rules issues. The respondent also failed to fully analyze the subject's amenities and condition and the neighborhood and market area, or properly document the analysis used to select the comparable sales. There was little to no support for the adjustments made in the sales comparison approach. The reasoning for not developing the cost approach was because it wasn't required by the client, and there were insufficient summaries of analysis to support the opinions and conclusions made. The potential violations identified in both reports were 12-10-613 1B and G, the record-keeping rule, the scope of work rule, and standards rules 1 and 2. The recommendation is for a final agency order, supervision of 8 appraisals in 4 months, and then coursework in appraising for the VA, which is 5 hours, the BOREA work file course, residential sales comparison and income approaches, and that's 30 hours, 5 hours or more in data verification, and the 15-hour use path course. And this respondent has prior board actions in 2005, 2012, and 2017. And Rob's here to answer any questions that you have.
Rob, this is one that might kind of go to our professionalism. It seems like this appraiser also had some issues about working with the client to make changes and updates. And did I read that correct?
Well, actually, on the 1936 case, the second one was he did do a revision. It seemed as though he invoked Tidewater for a VA to get new additional comparable sales. Then the lender provided the comparable sales, and basically he just took the new comparable sales, changed the appraised value a little bit, and just without any sort of thorough analysis. Also, he said something to the fact that the new sales comparable sales superseded the old one, so it didn't really have to do any sort of reconciliation between all of them. It was
Who
different.
uses 3 sales these days?
Lots of people have been using 3 sales, and also one of the big issues, also the 1936 case, is being a new built home. He decided since it wasn't required, he wouldn't have to do the cost approach. And then I also discovered that at least 2 or 3 of the homes were actually manufactured homes and not stick-built homes like the subject, and he failed to recognize that.
And one was a resale.
And yes, there was also a resale.
Of a 2-year-old sale, and yes, there's not a lot of difference, but there's difference between brand new and not brand new, and he didn't even discuss that. Okay.
It appeared he just took the comparable sales that were given to him by the lender and just put them in without doing much research whatsoever on the particular sales.
Okay.
So, Rob, this is Larry. There are certainly a lot of things that don't seem right here. I have just a general question, and this is on the first report. This is a property that's 20 plus years old. And just by way of education for me, if you look at the appraisal on the uniform appraisal form, page 2, what does it mean here when it says typed in wrong subject is part of subject comp 1, comp 2, middle of the page? It says wrong subject. What does anybody know?
Yeah.
What are we talking
I wasn't sure if that was him correcting something.
Yeah, and then I was also questioning, it says, date of prior sale transfer, and it talks about a 3/30/21 transaction that looks like it's $185,000. And I don't know that I just was confused with that. I didn't know what we were talking about there, given that it's currently, the current ask price or sales price was $335. And the date was not that dissimilar to that prior sale. That was just something that confused me. Anybody know?
I believe he missed the last sale, because this was actually like a flip property, and I don't believe he caught that.
Okay, so maybe that was somebody else's input. So.
Which,
Yeah, it might have been that Brian, it might have been the
Review.
comment made, the reviewer.
Right. Okay.
Yeah, all right, shouldn't have said his name.
let me double check.
It's on page 2 of that report, it says something about a comment by that individual. 11:30 a.m., 9/16/21.
Oh, I think that is. Let me double check. I think that is when he invoked Tidewater. Yeah, he invoked Tidewater on both of these properties. It seems like. Let me see. Was that in the. Oh, yeah. Oh, where it's in the reconciliation part?
No, what I was talking about is just on page 2. Maybe it's insignificant. I thought that was something he had put in. I don't want to waste a lot of time on it, but it's on the second page, and it's in bold. It says wrong.
Oh, I'm sorry. That was me.
Oh, okay, that's you.
That was me, because basically he had the wrong prior transfer date.
I got it. And it was 185. It's a fix and flip, and so they were flipping it at 335. And,
Exactly.
all right. And was there anywhere a description of what they've done and how many dollars they spent in the fix and flip? I mean, I didn't see it, and that's something I would have included.
I know he was provided with an extensive list of the items that were done. Let me see if where that might be. I know it was an extensive list of, it was basically everything is brand new. New roof, new HVAC, new windows. It was completely redone.
Okay.
And he was provided that list. Trying to see if I can find where I had put it.
It wasn't included in the appraisal, correct?
No, I don't believe so. He did put a partial list in the appraisal. Actually, it might be in Exhibit 8. Oh, yeah, in Exhibit 8, there is a list of the new items.
Okay.
Okay,
I
on
also
page 4.
noticed he didn't seem to update any of his information from 2020 to 2021. Talks about market condition from 2019 to 2020, and he never discusses anything beyond that. I noticed that 2 or 3 places in these appraisals, almost like he hadn't updated information.
No, it appears there was no real current information in there. Most of it was at least 9 months old. His adjustment for it looks like most of his adjustments were, he didn't provide the paired sales, but most of the adjustments appeared to be very old as well. And the same, even though they were, one is in Pueblo, one's in Pueblo West, they had the same gross living area adjustment on a 55-year-old house and a brand new house as well. So it appeared that he may have been using the same adjustments across the board.
So there's a lot of, do we have?
Yeah, I mean, Rob, I print all this stuff out. I still don't see the discussion that was done, but certainly trust you that that's in there. There's just a myriad of things. Going through, I didn't see any support for the adjustments that were made. I think it's egregious that you use manufactured housing sales and you're comparing those to stick-built. I think that you would try to avoid manufactured housing sales if you're, and vice versa, if you're doing a manufactured housing. So, and then no discussion of that. That it's pretty misleading to me, and certainly could cause an issue for a lender. These reports weren't well done in my opinion, and I've kind of agreed with your comments, Rob. So, anybody else have any thoughts that we should discuss before we talk about education, et cetera?
Well, Marcia, this is almost a question for you. I mean, in 2018, they had 4 supervised appraisals. Was that the board or the division reviewed those or supervised those?
I think back in 2018 we were doing those in-house.
And at that time, public censure now we're recommending 8 appraisals in 4 months that they have to get on their own.
Correct. And we would have done the work product review in-house. We wouldn't have done the supervision.
Oh, okay.
So if you look though, I mean, 2005, he had a stipulation for diversion. He had 15 hours of education and a $900 fine. 2012, he had a $500 fine, 30 hours of education, and 3 work product reviews. And then 2017, he gets a $2,000 fine, 26 hours of education, 4 supervised appraisals, and 1 work product review and public censure. It just doesn't appear to be improving.
Exactly.
That's kind of what I'm.
And based on the phone interview, it sounded that way as well. I mean, when we're talking about lack of support for the adjustments, I definitely got that impression from listening to the interview. And one of them was him talking about, well, in general, GLA adjustments are $20 a square foot, and Rob probed him about, new homes versus 55-year-old homes, and I think he said, well, in new homes it might stretch up to $24 a square foot, but he didn't seem to have any documentation of that for his research. It was something I've commonly referred to as tribal knowledge that seems to get passed down, and it's not written down anywhere. It's just, well, this is what I used years ago, and this is what the person that trained me used, and this is what the person I trained.
Can I ask a question, Director Waters, of you?
Yes.
The 8 appraisals in 4 months, would we or could we specify a number of those have to be VA related, since this seems to be specific to that? Can we get that specific with this, or?
I think you could make that. I mean, unless VA removes him from their roster for whatever reason, then he wouldn't be getting VA appraisals.
Okay.
Or at least make part of them, 2 of them out of the 8 or something.
He's also a certified general appraiser, so one of the considerations you could have, I mean, he's had a lot of education. It seems like something that definitely a certified general appraiser should understand.
Right.
He could downgrade the license.
Although all these were residential anyway.
Correct.
Madam Chair, board members, I'd be in favor of that. Definitely a pattern here to the point where I don't know that education is going to, or remedial education or any kind of supervision is going to provide a different outcome. Initially, I was more in favor of revocation. Appraisers shouldn't be appraisers. This one's demonstrating that pattern and trend. But if he doesn't have similar practices on the commercial side, I think eliminating residential from his license would be appropriate.
You mean commercial?
No, commercial.
This was, I'm sorry. Yeah. Yeah.
So you would allow him to keep his certified general, but do a practice restriction saying no residential?
Correct, if that's possible. I don't know.
Then he
You
wouldn't
can do
have
practice
anything.
restrictions.
I'm sorry.
You can do a practice restriction.
But if we
correct,
downgrade him to residential and we don't allow him to do residential.
Well, so what Tony was talking about was allowing him to keep the certified general credential, but doing a practice restriction that doesn't allow him to do residential appraisals.
Okay.
and we believe that his entire practice is residential. Is that correct? Or we believe much of it, or we don't know?
I don't think we know.
Okay. So we'll make this the problem of the people that are getting commercial appraisals. because, I mean, to me, the history and then these reports are relatively egregious. And we talked about, people using foul languages and communication. To me, as somebody that's been in the industry for 40 years, he may not be using foul language, but this is foul language. I mean, these reports are terrible. He's got a history of it. I don't know who said it. I mean, perhaps these kind of people that maybe shouldn't be in the industry, but in a way, we're restricting him from doing residential appraisals, which is severe. I'm not saying I disagree. We may be restricting him from the ability to make a living, because it may be that he doesn't do commercial, even though he's a CG. So.
Right.
Madam Chair, the other way to look at it, if he doesn't understand basic principles and applies them on a residential appraisal, I doubt that he's going to have that capacity to apply correct principles on a general or commercial appraisal as a general certified appraiser. But he's demonstrated the inability to perform a residential appraisal properly over a course of many years. And as Larry said, these are pretty egregious examples. I would not want to engage this appraiser for my house or anyone's house. And I think part of our responsibility is to license efficiently and discipline fairly. And this appraiser has demonstrated a lack of competency over a long period of time.
Like 20 years.
It's a tough decision, but I think, sometimes we have to make tough decisions.
So, would you recommend a suspension of a license until this was done?
As a compromise, I think that would send a stronger message to the appraiser. In addition to another round, a fourth and fifth round of remedial education, yeah. I would support that.
As opposed to revocation?
Yeah.
Okay.
Or a practice restriction, a permanent practice restriction. I would support a temporary suspension. And I don't know if we can for just residential for a period of time until he complies.
So, Tony, let me make sure I understand what you're saying. So, license would be suspended, period, commercial, residential, until all the coursework is complete. Of course, without a license, he can't do the 8 appraisals that will be reviewed, so the license will have to be reinstated, and then he or she would have the opportunity to then do the 8 appraisals that would be reviewed. Is that what we're thinking? Yeah.
I think you raise a good point. Without having an active license, you can't do the appraisals to get reviewed, but suspension until the completion of the other education items. Initially I'd be in favor of revocation of his license, commercial and residential. As a compromise, whatever the board consensus is, I would go along with. But I think we need to do something more than what we've done in the past.
I agree.
Board members, just to clarify, the recommendation was for 8 supervised appraisals. So he wouldn't have to have an active license in order to work under a supervisor. So this is a step up from a work product review.
Okay.
Right.
All right. So I think the next step after this would be revocation, him completely losing his opportunity to practice. So my recommendation would pretty much mirror Tony's. That is suspension of license until the 8 supervised appraisals are done and until all coursework is complete. Then a reinstatement of licensure at that point. And then if we have to readdress this, I think we need to have the memory that we've done what we could do, and then at that point consider revocation.
Madam Chair, I would second that motion.
Okay, Okay, so on complaints 2021-1593 combined with complaint 2021-1936, we have disciplinary recommendation of appraising for the VA, BOREA work file course, residential sales comparison and income approaches, and 5 hours or more of data verification, along with supervision of 8 appraisals in 4 months, and us recommending a suspension of the license until all the coursework and all the appraisals have been completed. And this will be a final agency order. All those in favor say aye.
Oh, let's have discussion first, please.
Okay, I thought somebody seconded.
Well, I just want to discuss this before we go to vote. I would just say that I would go along with this recommendation reluctantly. I think that this appraiser with a certified general license is an embarrassment, and this person is absolutely not performing to standard. And our job as the board is to protect the public. So I will go ahead with this vote, but my preference would be to just simply revoke his license. So for what it's worth, aye.
Any more comments on that?
You know, I think, Christy, I appreciate your, the perspective. I maybe it's too difficult for me to remove somebody's ability to earn a living when they have been irresponsible. So that may be an issue that I have. I think, though, what has been recommended by Marcy and the 8 appraisals that are to be done, I mean, it's pretty severe. It's going to, and is there a financial fine in addition to that, Marcy?
So we didn't recommend one. We've got some budget issues. So, and we need to kind of stop some of the revenue coming in due to the budget issues that we're having, which is not a bad problem for us to have. But I think with the supervision and also the coursework, that is going to be a pretty significant financial hit to this licensee.
Yes.
And I mean, given his tenure and everything, based on what you guys have kind of discussed already, he may just decide to kind of bow out of the industry at this point.
I mean, I think that this is a severe punishment, if you will, and like I said, I would hate, to Christy's point, to have all this completed and then to have the public put it in jeopardy again. But I think that what we've recommended is severe and will make a difference. Perhaps it hasn't for 20 years. So I kind of stand by the original motion, and then if there is additional complaint, then we'll address that maybe in finality at that point. So.
And I support that, Larry.
Madam Chair, board members, I don't want to get too formal, but we do have a choice. The motion and the second on the floor can be voted on. If it's not approved, we could then entertain another motion.
I think that we're sending a really strong message to this appraiser. So to be fair to this person's livelihood, let's give them one more chance.
So we have a motion and a second, correct? Or do we need to repeat it?
No, we have a motion and a second. You're correct. And now
Okay.
we can.
Now we can vote. All right, so all those in favor say aye.
Aye.
Aye. All those opposed? Okay, we've completed that one. Our last complaint is 2021 1885. James Fuller is the investigator.
So board members, with this complaint, this is an issue where the respondent was disciplined in Oklahoma and failed to report it to the board as required by board rule 13.7, and also it's a potential violation of 12-10-6131B. And this was discovered during the review of application materials for this person's trainee. And Jim is here to answer any questions you may have. We don't have a recommendation because I don't know the last time that we saw one of these. And I have another one kind of pending in my queue that was discovered through the review of another person's application. So if you don't mind, whatever you decide today to do with this one, I will just go ahead and do with the other person that's in the queue, and that will kind of set the standard.
From the response, I did believe that it was an oversight, or at least it was. What did you think of that?
Patrice, did you say you did not believe it was an oversight?
I do believe it was. I mean, it didn't seem like that big of an issue that could have been handled, and I don't know. Maybe I was getting soft here at the end.
I agree with you. I think I want to make sure I heard what you said correct.
Yeah, I agree that this person responded in the exact opposite, or they were the antithesis of what we started the meeting off with, which was that horrible note that somebody wrote. And this person was humble and apologized and said it was an administrative oversight, and we can only believe that what they're saying was the truth. And if I didn't take so many of these law courses around the country, I could have certainly been a person that didn't realize that you have to report these in 10 days. And that is, though, fairly consistent around the country. And for most states, you have to report very quickly. But, we're not reviewing the quality of the apartment appraisal that was done in Oklahoma by this appraisal. We're really just talking about, an administrative oversight. This may be not appropriate, but my perspective is this is kind of a warning. I don't even see that a fine is necessary. If it's a first offense and it's the first time, I don't know, Marcy, what kind of warning can we give?
So we've got a letter that we send out, and internally we refer to it as a letter of concern. In statute, that's not what we have, but it just basically kind of flags for them that they did violate a board rule and a statute in this case, and not to do it again. There's a discipline that goes with it.
Is that on their record? Will that be on their record going forward that there was a complaint, or does the complaint go away?
Well, so we'll know internally that there was a complaint, but because it's a dismissal, it won't be public record, and it won't be subject to open records requests.
But if it happened again, you would be able to tell us that this is the second offense they didn't report to us. Is that correct?
We would know that, yes.
And you would be able to let us know as a board? Okay.
I think a letter of concern is appropriate in this case and for other similar cases.
I agree. I think if it's the second offense, then maybe there should be a $100 monetary fine or something. But as a first offense, I agree with the letter.
So in complaint 2021-1885, do we have a motion on that?
I'll make the motion that the letter of whatever it's called is actually issued, no fine.
Second.
I'll second it. The letter of concern.
Right.
Very good. All those in favor say aye.
Aye.
Aye. All those opposed? All right, I think that concludes our investigations for today. Next, any licensing matters?
No?
None? Expedited settlement programs, none, correct?
Correct.
Any Attorney General matters that have come up since the agenda?
No, Madam Chair.
Okay.
Teresa, I have a quick question to Tony's comments early at the beginning. How would we as a board have any influence over the appraisal review process? Tony, what you were talking about with Texas sounds like a great idea, and that you really have a reviewer. There's no bias and no conflict because we're picking the reviewer, if you will. Is there anything the board can do to make what process? And maybe Chris, this is for you. What process would we have to go through to see something like that instituted in Colorado?
Can I ask a question? Marcia, this question might be for you. Is this what we agended for March 3rd, and maybe that would be a better time to discuss it, or is it appropriate to discuss it now?
So this is different than the agenda item for March, but I will tell you, so when we don't have a list of approved reviewers, and I think that would be difficult for us to manage because I don't think we can endorse any particular licensees. We do have standards about the selection of who they're going to have do their reviews or their supervision. We don't allow them to use family members because we see that from time to time. And the reviewers themselves do have to complete some paperwork for us about the reviews that they've done on the respondents' work. So it's not like they can just go out and pay somebody who then, tells us that everything is great and we just move on with that. We are checking the work that's done. We're just not reviewing the review that's done by the review appraiser.
Okay. All right. Just a thought. It sounds like maybe there hasn't been failure in our process. I mean, I just like the arm's length deal that Tony was talking about in Texas, but maybe that's not something that that the board takes up. So.
Well, and I think one of the problems that we face with your program is the workload kind of ebbs and flows. So there are times, like right now, we don't have a high complaint load to deal with, and we can take on some extra projects. Mm-hmm. There's other times, though, because of the ASC policy statements, we can't. We've got to deal with the one-year deadline on those complaints, and we've also got a 90-day deadline on processing applications, and the applications require experience reviews, and that's an additional project that the investigators have taken on right now, is to help get those experience reviews done. So the appraisal program is just, we have to be really careful about if we're going to do something above and beyond what we're required to do by statute. Mm-hmm. We just need to make sure that we have the capacity, and that's kind of why we went away from doing the work product reviews in-house. And we have had respondents that have had difficulty finding someone to help them do the work product reviews or do the supervision, and staff has sought out appraisers at that point to try to help them. But we do some quality control of the reviewers themselves because we don't want to set anybody up for failure.
All right. Well, that's enough. I just a thought. So thanks for entertaining that.
Is there anything else you want on your March agenda?
I don't have anything. So I think that we can adjourn the meeting. Correct?
Yes.
Okay. Well, Happy New Year, everyone, and see you in March, I guess.
All right. Thank you.
Thank you. You as well.
Board members.
Thanks, everybody.
Thanks.
Bye.
You're